Hi, welcome to another Lawdit podcast. My name is Izaz Ali and I'm joined by Lora Krostiva, who deals with litigation amongst other things here at Lawdit Solicitors. Today we were going to have a quick discussion about part 24 of the Civil Procedure Rules, which relates to summary judgment. And the reason for that is only earlier this week she was working on a case which warranted a summary judgment, and we'd had a long, lengthy discussion discussing the facts, and then she proceeded to make an application to the court for summary judgment, and I thought, what a wonderful topic to discuss on our weekly podcast. So I think it's something that we need to sort of go through from the basics and work our way up. So, Lora, welcome.
Hi, hello. Thank you, Izaz. Thank you very much.
I'm going to start off with just asking some basic questions. So, summary judgment, part of the Civil Procedure Rules. What's the benefit of it? What's the aim of it? Why consider it?
Yeah, of course. So the aim is essentially to enable either a claimant or a defendant, so it's important to note that both sides can apply for this, to obtain an early judgment without kind of proceeding the full route to trial and incurring costs that aren't necessary, wasting time for something that can pretty much be hopefully settled quite quickly. So that would be the summary judgment part. And it would be more appropriate in cases that are more straightforward rather than matters that are complex and require, for example, lots of expert evidence and lots of different types of evidence. And in that case, it wouldn't necessarily be appropriate because there will be more that might need to be explored at trial.
Okay, great. Yeah, that's... And on what basis can you make an application? What would be the legal terms grounds? So what are the grounds for making such an application for summary judgment?
Yes, so the grounds, they are under part 24.3 under the CPR. There are two grounds essentially. So the first one is whether, so you can apply for summary judgment if you believe that the other party doesn't have a real prospect of succeeding in the claim or in their defence. So that's the first ground to consider. The second ground is that there is no other compelling reason as to why the matter should proceed to trial, which, just bringing that back to what we said at the start, for example, more experts needed, other witnesses, evidence, those sort of things would be explored here. So just turning back to the first ground, which is the no real prospect of success. So what the court does is they will determine whether the case has a realistic prospect of success as opposed to some sort of mere chance of winning. So it must be more than merely arguable. And that is what the court will look at and decide.
What about the second ground that you mentioned, which was no other compelling reason?
Yeah, so like we said earlier, that would be something that doesn't need further investigation and that the matter is clear-cut. There's no further need to invest more time to proceed this to trial. So I think a very good example of that would be, again, witnesses, further evidence, reviewing any additional documents, matters that require further review in order to determine an outcome. That would be another reason. So if all of that is necessary and the judge deems that it's needed, the matter will need to proceed to trial as opposed to be granted summary judgment there and then, as there's more to explore.
Okay. Another interesting point to just cover off is in relation to timing, because this is something that was pretty key in our discussion earlier in the week. And I'll just sort of talk our listeners through that. So in proceedings, the claimant can't make an application for summary judgment until the defendant has filed an acknowledgement of service. So that's really, really early on. So just sort of talking you through that. You've got the claim form and particulars of claim, and they're issued. And once they're issued, the defendant is given some paperwork which includes an acknowledgement of service. And when they get that acknowledgement of service, within 14 days, they can, assuming they're defending their position, they can sign a date, return that acknowledgement of service and fill out some very brief information as to contact details. And then subsequent to that, they have an additional 14 days to then file their formal response in terms of a defence. There are other rules under the civil procedure rules where they can ask for more time to respond, but all of this must be done within that time frame, not once that time frame's elapsed. So back to the claimant, they usually make the application before or at the time of filing a directions questionnaire and the directions questionnaire will cover stuff like how many witnesses there will be, how long do we need for trial, how many do we need expert evidence, is this court suitable for the case, how long do you think you're going to need in terms of court time for the actual trial, all that sort of stuff. So that would be the timing of it. Now a defendant can apply for the summary judgment at any time, and usually when we're acting for a defendant, we do that at the very early stages, again, just to sort of reiterate that point that Lora mentioned earlier, and that is really to avoid any further costs arising, because any cases in court are expensive, and costs always and time involved is obviously significant. So in terms of procedure, a respondent is given at least 14 days of the notice of a hearing, and if there's any written evidence, witness evidence that needs to be reduced to writing, and it's got to be served 7 days before the hearing. We often sort of deal with it in the way of putting together a small bundle of documents, all paginated, all linked, so that it's easier for the judge and the other side to be able to sort of go through that and deal with that. And if the applicant themselves want to rely on written evidence, then that's done. It's got to be filed at least 3 days before the hearing. And again, any information that they provide can then be just added to the bundle. It's quite normal for us to do electronic bundles, so it's quite easy to add documentation onto that and then provide an index linked bundle to the court and to the other side, so that it makes it easier. So what happens then when you go to the hearing? So at a typical hearing, a judge can give judgment on the actual claim. He can strike out or dismiss the claim. He can dismiss the application. He can make what we call a conditional order, and that it can be like ordering a party to make some payment into account into court, or to carry out a specified step in respect of any aspect of the claim or the defence. But importantly, if someone fails to comply, it can lead to striking out the case. And I think that's always the point to sort of consider. Lora, back to you. Can you talk us through any sort of, benefits, drawbacks in relation to going for a Part 24 summary judgment application?
Yeah, sure. So there will be kind of things that are important to consider and would, sway the decision of how we proceed. But yes, so the advantages of summary judgment would be, of course, as we've already mentioned a few times, you're saving expense, you're saving time of taking a matter to trial that doesn't necessarily need trial. And that's obviously if your application for summary judgment is successful. It also, in the same sense, really gives an opportunity for your application to be determined in favour of the applicant, whether that's the claimant or defendant, at an early stage in the proceedings, and then hopefully to consider the matter closed in your favour, or however it may end. So that kind of also ties in with the saving time, expense, and money point, which we've already mentioned. And of course, there is a very, very big tactical advantage in also making this type of application, which is that even if you apply for summary judgment, but you're unsuccessful, you're still able to see your opponent's case, and you'll be able to see what you're truly dealing with, and you'll see, kind of the cracks in their case or what you need to kind of strengthen up on your side, and you'd be able to then deal with that accordingly moving forward if the matter then does proceed forward and you're unsuccessful in the summary judgment. And it's also possible, another advantage this is that you can make more than one application. So this is usually where there's been a change in circumstances, and of course this would always be in accordance with the overriding objective of the court if it considers it to be in accordance with this. So those were some of the advantages for making or applying for summary judgment.
I'll run through some of the disadvantages then.
Yeah.
So really from memory, so delay in incurring further costs of the proceedings if the application is unsuccessful. If the application is unsuccessful, then it's possible that the applicant will have to pay more costs to the other party, as well as obviously their own costs of going to court. Even if we're successful, the opposing party may appeal the decision of the judgment, so it's always worthwhile factoring that aspect of it in. Costs, which is the final point, really is, I think, arguably one of the most important points, and that is that costs are always made usually at the end of the case. Costs are in the case. If they're not agreed, then they're assessed. But if we are looking at a defendant who is successful in a summary judgment application, it's quite normal and usual for the judge to award their costs in relation to that. So back to you again.
Okay, thank you, Izaz. I think that would conclude definitely the basics of summary judgment. So we've gone through what summary judgment is, the grounds that you can rely on when making an application, timings that you must consider when making it, and also some advantages and disadvantages, and finally costs, which some very, very important points to run through. So yes, that would be kind of the gist of it. And if you've got any questions or any matters concerning what we've just discussed, please do get in touch with the Lawdit team today, and would be more than happy to assist you.
Thank you.
Thank you very much.